Welcome to Consumer Law, What Is It Good For?, where we look at, consider and try to answer frequently asked questions put to us here at Stormcatcher Law through our free advice helpline and from clients. And in this video, and by popular demand, I'm going to look at the Consumer Rights Act 2015, which of course is 10 years old this year. And importantly, I'm going to look at why I say, and you may agree, that it's not working. So for a little bit of background, 10 years ago, according to a report commissioned by the Citizen Advice Bureau, the amount of net monetized consumer detriment, that's the amount of money that consumers lost because of poor quality goods and services bought from businesses, was estimated to be £22.9 billion. And the Consumer Rights Act was implemented to reduce that. It was hailed as the single biggest piece of consumer law in a generation. But fast forward on a decade, and the Consumer Detriment Survey by the National Centre for Social Research, which was published in March this year, March 2025, for the year 2022 to 2023 to 2024, estimated the net monetized consumer detriment, that's the amount of money that consumers lost because of poor goods and services bought from a business, was estimated to be 71.2 billion. Now, whilst the economy, of course, has grown in the last 10 years, it hasn't tripled in size as the amount of detriment has. So it won't be a great surprise to you, and it's a no surprise to me, that the vast majority of people that call places like this are consumers with legal problems. And for us, those problems involve the sale of goods and purchase of goods such as cars, motorcycles, vans, boats, and pretty much everything with an engine or a motor, and services including vehicle repairs, servicing, restoration, and so on and so forth. So when I look at the inquiries that come in and the letters that we receive from and about new and used cars dealerships, car warranties, car finance companies, the motor ombudsman, the financial ombudsman, and even legal professionals, it is more than apparent that the Consumer Rights Act 2015 is misunderstood, misquoted, and misapplied. Now, whether that's by design or by ignorance, to some extent, matters not, because the end result is the significant rise in consumer detriment that I've just described. So because of this, I'm going to do a series of videos which specifically looks at real-life cases and complaints involving the Consumer Rights Act. And I'll be dealing with all the usual suspects, satisfactory quality, fitness of purpose, description, as well as the right to repair, replacement, rejection, and all the usual questions that go with those. But first, and in this video, I think it's important, or hopefully will be interesting and useful, to understand a bit more of the background as to why we're in the state that we're in. So I'm going to give you some explanations for that. So first things first, I think we need to look at what consumer law is. Consumer law, perhaps unsurprisingly, is part of the civil law as opposed to the criminal law. And the Consumer Rights Act is only one element of civil law, of course. It's not the only trick in town. And consumer law and civil law in general is a comprehensive, specialist, self-help legal toolkit. I think that's the best way of describing it. So there are a set of tools there that are there for you to harness. It's not like the criminal law, which is investigated and prosecuted by the state. So you report a problem, hopefully the police investigate it, arrest someone, and the Crown Prosecution Service then prosecute that person. It's not like that. there's nobody else doing the heavy lifting for you. You have to sort out the problems or hire a lawyer to do them. Okay. Now, because of that, because there's not that third party coming to your aid, in my view, you can't, as much as it's unfortunate, you can't realistically expect the business that you are complaining about to help you hold them to account. And you therefore can't be surprised, in my view, if you don't get the reply you want, if you simply tell the business that, you must supply goods that are satisfactory quality and fit for purpose. That sort of finger wagging approach is not one that's likely to get the results that you want. And it is that is one of the main reasons of why I'm not a fan of the template letters that you can download from the Citizen Advice website and other places, just because they're too generic. They use those sound bites without explaining precisely what the problem is and what you want doing about it. So what you have to do, in my opinion, is you have to take a more strategic approach. And this is going to involve combining the relevant facts with the evidence, properly evidence, maybe using the rules of evidence. You've got to look at perhaps other statutes. Maybe statutes are legislation, and those things like the Consumer Rights Act that end with the word act, for example. You may have to look at the common law, which is part of your toolkit, and common law is our previous court decisions. Precedent is what it's about, looking at previous court decisions to help us interpret statutes, to help us have some consistency in outcomes, and to give an authoritative approach to your reasoning. And through that, you build a winning strategy. That's what lawyers do. But it doesn't mean you have to be a lawyer. But what you do have to do is properly explain what the problem is. You have to evidence that problem. You have to explain the rules that the business has broken and how that makes them liable, and ultimately what you want them to do about it. So the second thing I'm going to look at is what is the consumer rights all about? So the consumer rights it's all about contracts. It's all about contract law, specifically for goods and services sold by business to consumers. And every single day we're surrounded by these contracts. We enter these contracts all day, every day, whether we're buying a big ticket item like a car, or we're having it repaired, or we're buying a washing machine, a fridge, a mobile phone, and pretty much everything in between. And what the law does, particularly that statute, the Consumer Rights Act, is it sets the standard. Okay, the minimum standard of quality that we should be expecting as consumers from these products and services, so that they are satisfactory quality, fit for purpose. You know all of those words, okay? But this isn't a new concept. We've had a long history of law relating to the sale of goods and services in this country, which first, as far as the goods are concerned, came about in 1893. It was revised in 1973 for goods that are sold on hire purchase, 1979 for goods that are not sold on hire purchase, and then it was amended again in 1994 and then 2002, if I remember. In the midst of that, we also had the Supply of Goods and Services Act, which dealt with services and also mixed contracts, those contracts where a business supplies goods and installs them, like a plumber may supply a boiler and install it for you. And these laws originally applied to consumer contracts and business-to-business contracts, and the Consumer Rights Act provided a separate version just for consumers. So we now have two sets of rules: Sale of Goods Act and Supply of Goods and Services Act for business-to-business contracts, Consumer Rights Act for consumer contracts for goods and services. So what's the difference between the two? The Sale of Goods Act and the Supply of Goods and Services Act are statutes, and they, as with the Consumer Rights Act, set the minimum standard that businesses, in that instance, should expect. If we want to find out what your rights are for a breach of the Sale of Goods Act, we have to refer to the common law. We have to look through previous court cases to assist us in giving us definitions for the words that are in those statutes, to assist us in the potential outcomes, the authorities, and what those rights may be. Okay, it's not just about trying to find, if you've got a car case today, looking just for car cases in the past, although some of those will be helpful, but it's also about finding answers and definitions to different words, different circumstances, and so on and so forth. It's all about trying to find consistency. Okay, that's what it's all about. If we use the common law and we apply it properly, we'll end up with similar answers today that we had before, and that will help us predict the future, and that will help us predict human behaviour and hopefully curtail bad behaviour. This is also, perhaps unsurprisingly, the method that we use in the criminal law. It's exactly the same. And I'll just give you a little example. I'm not a criminal lawyer, but all lawyers have studied criminal law. And I'll use the Theft Act, 1968, which is a statute. And that defines what the offence of theft is as a person is guilty of theft if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it. So to successfully prosecute someone of theft, the prosecution must prove the key elements of the offence, which in this case is dishonesty, appropriation, property belonging to another, and intention to permanently deprive. And those definitions, what that means, in what does dishonesty mean in law, and so on and so forth, what's intention mean in law, we find those answers in the common law. That helps us with that jigsaw of building that case. And that's how we get that consistency. If we then contrast that or compare that with the Consumer Rights Act, the Consumer Rights Act starts off in a very similar fashion. It says, I'll quote, every contract to supply goods is to be treated as including a term that the quality of the goods is satisfactory. Then it goes on to say, the quality of the goods is satisfactory to meet the standard a reasonable person would consider satisfactory, taking into account of all the things you know, the description, the price, the appearance of finished, safety, durability, you know those things, okay? So the Consumer Rights Act sets the standard in exactly the same way as it does in the Sale of Goods Act, but it also sets out the remedy, what you are entitled to if things go wrong, if the contract is breached, in the same way as you can find in the Theft Act what the sentence may be. It could be a summary conviction, which is perhaps up to 6 months. It could be an indictable offence, which could be 2 years. It's all in the law. Okay, so in this case, the Consumer Rights Act gives us that answer to what happens if you don't get supplied with goods that are of the right standard, such as the right to repair, the replacement or rejection. All looks great. So what's the problem? The problem is, under the Sale of Goods Act laws, for business to business, under the criminal law, we have to use the common law to help us define and provide consistency. But have a look at those letters that you're receiving, like I have to do, in response to those complaints, and ask yourself, how many times have you seen a letter from a finance company or an ombudsman which makes any reference at all to any previous court decisions? Are there anything in there? Is there anything at all that says, according to the case of Smith versus Jones, 1843, whatever the case may be? I'm not sure I've ever seen one, to be perfectly honest. That may be a little disingenuous, but it's so infrequent as I can't recall off the top of my head. And of course, without that, without that authority, without those reference points, there can't be any guidance from history and there can't be any consistency. And the problem is, if we don't have that in our legal system, this creates ambiguity, this creates uncertainty, and those two aspects are a breeding ground for bad behaviour, for exploitation, and ultimately criminality. So it may not be a great surprise why, in my opinion, automotive fraud and crime is higher than it's ever been. But ultimately, it takes money out of your pocket and my pocket and out of the economy. And this vagueness about the law has led to businesses, the sorts of business I just mentioned, to deal with Consumer Rights Act complaints rather than modify their behaviour to avoid them in the first place. And for me, I believe, and I think it's probably self-evident, that this has led to these firms effectively making up the law as they go along. They've created excuses and decisions and reasons to not uphold your complaint, for example. And I'll give you a couple of examples of the stuff I've seen in the last week or so. I've seen, I think the financial ombudsman, forgive me, I ask a question about, I put them to task about something, and they quoted the motor ombudsman's website as if that's an authority for anything. I've seen an automotive engineer in this last week quote from online forums as evidence that that person believed was capable of sustaining scrutiny in the High Court. I've seen people refer to Wikipedia as if that is a authority for anything and everything as far as that's concerned. I've seen this week, I think it was, a finance company state that it doesn't accept diagnostic reports from main dealers because there's a conflict of interest. And they went on to justify that the conflict apparently is that the main dealer may say there's something wrong with the car when there's not, just so they can win the repair, get the money out of it. The irony is in that same letter, the finance company went on to suggest that they would instruct and pay for an expert report that they say is going to be independent and impartial, when one may equally think that the expert may just be doing what the finance company wants to do because they're being paid for it. It makes no sense at all. So, how can you deal with this? So, it's quite a simple strategy. Okay, so if you're presented with a reason as to why your complaint is not being upheld, or you're told that there's something you must do before your complaint will be looked at, you simply ask them to explain on what legal authority do you rely, which says I have to do this or says I can't do that, for example. If they can't provide you with an authority, any other rationale for their reason, there's a very good chance that they essentially made it up. Okay, and I'll give you another example. I had a letter from the Financial Ombudsman Service this week in relation to a very serious case where a gentleman's vehicle was destroyed by fire. He'd only had the vehicle a couple of months, and there was no doubt at all that the vehicle had been destroyed by fire. It literally was a pile of ash from that point of view. There was no doubt at all that the cause of the fire emanated from the vehicle as opposed to vandalism or anything from that point of view, within 2 months of purchasing it. And the Financial Ombudsman said that the consumer would have to provide evidence of precisely what it was, what component had actually failed so as to cause the fire. That makes absolutely, how could he possibly do that when the vehicle is literally a pile of ash? Ridiculous. Surely the common sense approach is cars aren't supposed to catch fire. They're supposed to be safe. He's only had it 8 weeks. He's only covered 1,500 miles. If it bursts into flames so that it is destroyed, by definition, that vehicle cannot be safe, and it definitely hasn't lasted for a reasonable period of time. 8 weeks cannot be acceptable for a £25,000 vehicle. You don't go to the customer and say, you have to find out exactly what went wrong. It's just not possible. Ridiculous situation. That's the sort of person that one needs to say, okay, if you think that's the right answer, prove it. And that's really important as far as that's because I've had it many, many times with engine failure, that somehow people think that you have to prove precisely which component failed, which eventually resulted in the engine being destroyed. That's just not true as far as that's concerned. So just remember, anything that you receive, and there'll be plenty of them, that feels you're not sure about, it sounds like it's nonsense, it feels like it's counterintuitive in terms of common sense, you simply have to ask the author of that letter to explain where the legal precedent is. What's the legal authority? From where do you find that information? And if people turn around like they do say, well, it's the Financial Ombudsman Service rules or it's our internal policy, you have to say, prove it. Send me those policies and that information so I can check it. So hopefully this video has given you some indication of what's wrong with the Consumer Rights Act. We're just Googling it, we're looking at it, we're making it up as we go along. We're not looking at those legal authorities, which has led to it being a bit like the Wild West out there. If you've got questions, send them in, knowledge@stormcatcher.co.uk, or give us a call 0333 700 7676. I hope this video has not been too much like a law lecture, but we've got to go back to basics. And in the next videos, we'll be dealing with those real life cases that you send in. We'll be applying the law, we'll be applying the common law, and we'll get the opportunity to see the law in action. I hope this has been helpful. Thanks for watching.